You've been hurt in a car wreck and it was not your fault. I know you have questions and this webinar will answer a lot of them. But before we start, please let me stress this to you. The information I'm sharing with you is general in nature. It's not designed to provide specific legal advice regarding you and your potential claim, because nothing can replace a consultation with an experienced attorney to discuss the facts about your particular case. Further, should you have any desire to explore pursuing your claim, you should not delay, as there are various statutes of limitation which could limit or completely bar your claims for recovery if you do not act in a timely fashion. So I encourage you, if at any time during this webinar you want to ask questions about your specific case, then please pick up the phone and call us. The consultation is free and the call is completely confidential. 770-934-8000 or toll free 1-888-934-8100. Okay, let's get started. What are the three things you must prove in your personal injury claim? 1, that someone was negligent in causing the wreck. 2, this person's negligence was the proximate cause of your injuries. And 3, you have to prove the damages you sustained in the wreck. Now, this may sound somewhat complicated, so let me break down each of these three elements for you. Negligence. This essentially means that someone is at fault. We have to prove that someone besides yourself was at fault for causing the wreck. The injured party has the burden of proof in showing that the defendant driver was negligent in causing the wreck. For example, when the defendant rear-ends your car because they did not maintain a safe following distance or they failed to keep a proper lookout of the road ahead, they were negligent. When the defendant rear-ends your car because he did not get his brakes repaired, even though he knew they were not working properly, he is negligent. Other examples can include following too closely, driver distractions due to them using a cell phone or adjusting the radio, speeding or traveling too fast for conditions, tailgating, driving under the influence of alcohol or some illegal drug, failure to yield while turning left, driver fatigue because they drove their tractor trailer more than federal law allows. The next element, proximate cause. Once we prove the other driver was negligent, then we must show that this negligence was the proximate cause of your injuries. Here's an example. You're at a complete stop at a red light. The defendant is not paying attention to the road ahead and he crashes into the rear of your car. Your head hits the steering wheel. His negligence was a proximate cause of the wreck and your injuries. Here's another example. You have a green light allowing you to proceed straight through the intersection. The defendant is traveling in the opposite direction. He does not see you and he attempts to turn left in front of your car and crashes into your vehicle. You sustain a broken arm and leg in the crash. His failure to yield while turning left is a proximate cause of the collision and your injuries. Now, the final thing is damages. When we prove that the defendant was negligent and his negligence was the proximate cause of the wreck, we must now prove what damages were inflicted upon you. Now, damages could include compensation for your medical bills, which could be ambulance, emergency room, the emergency room physician, the radiology bill, medical doctors, any specialists, chiropractors, physical therapy, any prescriptions that were written for you for the wreck. This is easy to prove, as all of these healthcare providers, the suppliers, will issue an itemized statement or a bill for the services they provided to our clients. Other items of damages, lost wages. Typically, if someone misses a week of work due to a car wreck, it can be proven with a couple of check stubs showing the time missed from work, a doctor's disability slip, and a wage verification form signed by the employer. But it can be very problematic if someone misses time from work, but they're paid under the table and there's no record on the books. It gets even messier when there's no mention of his work on the tax returns. So lost wages is one of those areas I encourage you to speak with an attorney. Transportation cost. Look, you would not have to be driving around from your home to doctor's appointments, to physical therapy appointments, or to get your prescription filled at the pharmacy if the defendant had not caused the wreck. This is clearly money that's coming out of your pocket that you would not have lost if the car wreck had never happened. You should be compensated for this loss. Gas is expensive. Parking in some of these private lots can also add up. So keep track of your round-trip mileage to these appointments and save those parking receipts. Another item in damage, future medical expenses. Obviously, no one has a crystal ball to tell you everything the future is going to hold for you medically. However, doctors can sometimes tell us to a reasonable degree of medical certainty what they anticipate you will incur should you eventually need, say, a surgery or have to undergo additional tests down the road. The key component to making a claim for these future medical expenses is to get a doctor's narrative that addresses your medical needs, why they're necessary, how they were caused by the wreck, and the cost associated with these procedures. Future lost wages. The standard for us proving future lost wages is very simple, yet it can sometimes be a difficult hurdle for us to overcome. The way a jury measures future lost income is for them to determine what the plaintiff would otherwise have earned in his job or profession but for the injury. The future lost earnings cannot be speculative, and you must have documentation to substantiate your claims. Finally, punitive damages. Sometimes the defendant's conduct in causing the wreck or his actions immediately after the wreck are so egregious, the law allows us to seek additional damages known as punitive damages. Now, the purpose of punitive damages is to punish, penalize, or deter the defendant from repeating the conduct. Let me give you some examples. We can seek punitive damages in cases where, say, the defendant causes a wreck and he attempts to flee the scene of the collision, or the defendant was driving their vehicle while under the influence of drugs or alcohol. And under Georgia law, there's a legal presumption that someone is under the influence of alcohol if the blood alcohol level is above 0.08. And another element of damages are known as general damages. These are designed to compensate an injured victim for losses such as pain and suffering, emotional suffering, hardship, or inconvenience. Now, these damages are hard to quantify for everyone and are highly subjective. So the law instructs the judge or the jury to assign these damages on an individual basis. And the amount of pain and suffering that someone is going to experience is based upon the enlightened conscience of a fair and impartial juror. And they have to apply the facts and law of that specific claim to your case to determine what the pain and suffering is. And there's an old adage, the easiest pain to bear is someone else's. There's a lot of truth to this statement. It's a challenge to get a jury to understand the degree of pain and suffering someone experiences because of a wreck, especially when the injuries are not visible. This is clearly one of those areas where an experienced personal injury attorney can help argue the specifics of your case to the insurance adjuster. Now, let's talk about the 3 major secrets the insurance company doesn't want you to know about your personal injury claim. Number 1, you will get more money for your injury claims if you hire an attorney. Think about it. Insurance adjusters are trained to act like your long-lost friend coming in to help you in your time of need. Do not fall for this trick if you or a family member has been hurt in a wreck. In 1999, there was a survey conducted by the Auto Accident Victims. This was in conjunction with the Insurance Research Council. This study revealed that injured victims receive an average of 40% more money just by consulting a lawyer to learn their rights. And injured victims receive an average of 3.5 times more money before legal fees when they hire an attorney to defend their rights. People have to remember that insurance companies are for-profit businesses, and one of the ways they make money is by not paying full value on these claims. Now, the second secret, insurance companies practice the 3 Ds when they defend claims. They delay, they deny, and they defend. Let me explain. Delay. When an injured victim is hurt in a car wreck, they're really bent over the financial barrel, and the insurance companies knows this. So they can get people to accept a lot less money by delaying settling the claim. Deny. If you submit a claim that you were injured, the claims adjuster will attack your injuries in a variety of ways by alleging, 1, you're faking your injuries. 2, you're exaggerating the severity of your injuries. 3, if you're really hurt, it's because you were injured before the wreck. 4, if you're really hurt, you should have gone to a different doctor than the one you chose. Or the adjuster will deny your case and put the blame on you for causing the wreck. And the third thing they will do, defend. If you do not like what the insurance company is offering or the insurance company denies your claim, you have 3 choices. 1, you can drop your claim. 2, you can accept the lowball offer. Or 3, you can file a lawsuit. They will use the court system to defend, delay, deny your claim as your case falls in line behind other civil matters, including business disputes, divorce cases, collection claims. This is not certainly the image the insurance companies try to portray in their TV ads. And the third secret the insurance company doesn't want you to know about your claim, do not sign any papers or talk to the insurance company before consulting an attorney. It does not help you in any way to sign anything or speak with the other person's insurance company. One, you could be signing a release of all claims without realizing it. Or two, the insurance company can tell you they're just making a list of your injuries and they ask you for a recorded statement. You do not say anything about your lower back because you just assume you're a little sore from the wreck and it'll quickly improve. A few weeks later, you do need treatment because your lower back is still hurting. The insurance company will come in and deny it, saying, hey, it's not related to the wreck because you didn't mention it in the recorded statement. The insurance adjuster that represents the person at fault for the wreck is out to save the insurance company money, not to give you the compensation you deserve. Finally, a question I'm often asked by people is, how do I choose the best lawyer for my case? Please understand the hiring of a lawyer is an important decision and it can literally make or break your case in some situations. I'm going to give you 5 tips you can use to help you find the attorney best suited to help you with your claim. Number 1, find out if the attorney specializes in the area of law in which you need him or her. For example, if you're hurt in a car wreck, you don't want to hire an attorney that mainly handles divorce cases or DUI cases. In my opinion, the days of an attorney handling all legal matters from divorces to real estate closing to auto accident claims, those days are long gone. You've heard the old expression, jack of all trades, master of none. Well, I firmly believe this because laws change constantly, and it's very difficult, if not impossible, for an attorney to keep current on the latest happenings in every legal arena. Now, attorneys can claim they specialize in a certain area of the law, but do your due diligence to verify this. If the attorney says he specializes in personal injury claims, but his or her website lists cases outside the personal injury arena, like bankruptcy or criminal defense or collection defense matters or real estate closings, then there's a good chance they've not handled or do not handle a lot of cases for car wreck victims. Number 2, find out if the attorney is recognized in your field as an expert by other attorneys. What awards, what honors has the attorney received? For example, I've previously been recognized as a super lawyer by other lawyers here in Georgia. This is an honor that's given only to the top 5% of the attorneys in the state. Another way you can see if the attorney is respected in the field is to find out if he or she lectures to other attorneys around the state in their practice area. Look, I've taught other attorneys that devote a substantial portion of their practice to personal injury claims how I handle car wreck claims at my law firm. I, along with Derek Hayes at the firm, we're both members of the Multi-Million-Dollar Advocates Forum. This is one of the most prestigious groups of personal injury attorneys in the world because membership is limited to attorneys who have received a settlement or verdict of at least $2 million. Now, the third tip to consider, it's very important that the attorney has experience handling your type of claim. Find out how many cases this attorney has handled similar to yours. You don't want your case to be the first for this attorney. For example, my law firm has helped over 30,000 injured victims and their families in cases involving serious injuries, deaths, and car wrecks, workers' compensation claims, nursing home abuse, and because of defective products or drugs. The fourth tip, I also believe the size of the law firm matters and not necessarily the number of attorneys the firm has. Let me explain this. As attorneys, we're often in court. We're away taking depositions or out meeting with experts on our cases. We aren't always available to answer our clients' questions immediately. And it's important for the attorney to have a knowledgeable support staff to assist you with questions when the attorney is not available. The fifth and final tip, find out if the law firm uses the latest in technology. At my law firm, you will not see a big law library because we don't need all those legal books, as all of our legal research is computerized. I've invested hundreds of thousands of dollars in state-of-the-art computer hardware and high-tech programs specifically designed to better serve our clients' needs. When you call, we can instantly access your client file to tell what has happened, what will be happening with your claim. This process allows us to efficiently handle your case and keep you better informed. Let me give you one final tip, and this is an important tip on who not to hire. Do not hire anyone that contacts you out of the blue and says they have a doctor or a lawyer for you and your claim. We call these people runners. They have friends that work in the department that handles police reports. These friends will then sell a copy of these police reports to these runners. The runners will turn around and start calling the people who were not at fault in the wreck. Their goal is to refer the injured victim to an attorney or to a chiropractor so they can represent them. And if the attorney or chiropractor signs up the client, they pay this runner a referral fee. Look, this practice is illegal, unethical, and attorneys should never be involved soliciting cases like this. So please never, never, never hire any doctor or attorney that will solicit you to be their client or patient. It's unprofessional, unethical, and illegal for them to be doing this. Everything I do to market my law firm is completely within the rules set forth by the State Bar of Georgia. I let people know that I'm here for them, and if they're hurt, if they have a question about their claim, or if they have a question about the insurance company's responsibilities, then I'm just a phone call away. Now, I hope this webinar has proven helpful to you. And please understand, it's just a starting point for you to learn about your car wreck claim. And hopefully I've provided you with the information you need so you can openly discuss the facts and the law as it applies to your claim with your personal injury attorney. But remember, please, no two cases are alike. And the information I've shared with you is not and cannot be a one-size-fits-all manual that applies to every car wreck claim here in Georgia. Nothing can replace you taking the time to have the specific facts of your case thoroughly discussed with an experienced personal injury lawyer. We would be more than happy to talk with you about your claim. The consultation is free and completely confidential. 770-934-8000 or toll free 1-888-934-8100. You have absolutely nothing to lose by calling us. But please, think of all you can lose if you don't. I look forward to hearing from you.